I get brought in ideally early in a case, and we will, possibly do a focus group that can be used as a guide for discovery. There are comments from the focus jurors that if you and I had worked on this case for the next 5 years, we wouldn't have come up with. And actually, that's the whole point of doing them, right? It's that they come up with things that we don't.
I'm really excited to have Amy Pardieck as our guest. Amy is a nationally renowned trial consultant. She's the owner of Perceptual Litigation, and she has years of experience working as a trial consultant all over this entire country. She's one of the top trial consultants, and she's worked with some of the best lawyers on some of the biggest cases throughout the United States. This is After the Crash. I'm attorney Dave Craig, managing partner and one of the founders of the law firm of Craig, Kelley Faultless. I've represented people who have been seriously injured or who have had a family member killed in a semi or other big truck wreck for over 30 years. Following the wreck, their lives are chaos. Often they don't even know enough about the process to ask the right questions. It is my goal to empower you by providing you with the information you need to protect yourself and your family. In each and every episode, I will interview top experts and professionals that are involved in truck wreck cases. This is After the Crash. Welcome, Amy.
Thank you. It's an honor to be here.
This is, as you well know, I started this podcast so that ordinary people that had questions about the process could go to the podcast and learn something. And I think a lot of folks don't know what a trial consultant is. They have no idea. They may have seen something on television or they may have seen something in a movie, but they really don't understand, what is a trial consultant? Why is my lawyer hiring a trial consultant? And is it, worth the money and the investment? And so today I'd like to enlighten folks on the area of trial consultant. So maybe why don't we start off with just telling us, what is a trial consultant?
So a trial consultant assists lawyers in different aspects of the trial. It can be preparing the case for trial or during trial and even after trial, conducting post-verdict interviews. And I think of the trial consultant as being sort of the people expert in the practice of law. So the lawyers, you, David, are the expert in the legal part of it and the legalities, which can be consuming, and trial consultants are often sort of the experts on the juror's perspective or the lay perspective on cases, because as you know, facts don't usually speak for themselves and everybody can see the same thing very differently. Some people will say that a truck was driving fast and other people might see that speed as slow or normal. And so the trial consultant brings in the different perspectives, specifically the jurors' perspectives. And so I think of us as sort of a bridge between the jurors and the law or the legal side of it.
And I think that's, and it's extraordinarily important for people to understand. Lawyers spend a lot of time becoming lawyers. They go to law school, they learn about the law, they learn to think in a certain way. And I know when I have my young trial lawyers, it takes me time to make them unthink the way. But I think law, that's a perfect, law is a hard thing. It's hard for us to keep up. It's a lot there, but no part of law school, or very little law school, actually focuses on juries or ordinary people, how they think. And so I think there is a big difference between the way the lawyer thinks and a trial consultant thinks.
It's shocking for me sometimes to be brought in on a case and the attorneys have had no training on jury selection or no training on juror decision making or basic communication skills. And actually, I think sometimes law school unlearns basic communication skills that law students go in with, and then they come out, and there's just so much that you all have to stay on top of, and the laws are ever changing, and the content part of it, I feel, is so consuming for you all. And I mean, we all have only so much bandwidth, right? And so sometimes it's helpful for you all to delegate to a trial consultant, doing some jury research or focus groups or mock trials to get to know the lay perspective, and then bringing that into jury selection and identifying, what backgrounds that jurors might have or experiences they might have that are particularly relevant to a case, or make sitting on this case particularly difficult for a specific juror.
Well, how does one become a trial consultant? I mean, I know that I've listened to and I read, and I study more today than I ever did even when I was in law school. Maybe I didn't study as well as I should have in law school, but I've seen lots of different types of jury consultants with lots of different backgrounds. So how does one become a jury consultant?
That is so true. So it's becoming a more popular profession, and actually the more trials I assist with, it's more common that the other side has a trial consultant as well. So there is a professional organization called the American Society of Trial Consultants that you don't have to qualify to become a trial consultant. There are no specific licensing procedures or anything like that, but the professional organization provides standards that trial consultants who are members follow. You don't have to be a member of it to be a trial consultant, but I recommend working with a trial consultant who is, because it does provide some baseline standards that are important for us to follow. And there are approximately 500 trial consultants, I believe, in the country, and we come from all different backgrounds. There are some who are lawyers. My background is in clinical psychology. I worked as a family therapist actually before becoming a trial consultant. There are trial consultants with acting backgrounds, communication backgrounds, business backgrounds, human relations or business, public relations background. So there's the whole gamut. And I think the point of that is that we all bring in a different perspective that is useful to the attorney clients we work with, and ultimately useful to the jurors. I mean, our job is to assist the jurors in doing their jobs. So I think most trial consultants come at trial consulting from another profession. There's a huge learning curve to becoming a trial consultant. It's not the kind of thing that you can get out of undergraduate school or even graduate school and just jump in. So I worked as an intern at a trial consulting firm for several years, and then became an associate trial consultant, and then kind of worked my way through collecting experience to being able to stand on my own 2 feet and work on my own as a solo practitioner. And most full-time trial consultants do have some sort of path that they've taken to get to where we are at this point.
Out of curiosity, what was it that caused you to have that interest to go into to trial consulting?
Well, I've always been interested in the law. Actually, I'm the only person in my immediate family who is not a lawyer. So both of my parents are attorneys and my siblings are attorneys, and I always toyed with going to law school, but I like the people part of the law. I loved going to trials with my parents as a child, and observing and being a gopher, but I knew that I was not cut out for the library research aspect of the law. And then that's a big part of, especially for young lawyers, everybody has to go through sort of that evolution to become a trial lawyer. And I knew that just wasn't for me. So when I became aware of trial consulting, it was just a perfect fit of my interest in people and decision-making and what motivates people, and also my interest in the courtroom and the legal aspect of it. And I actually lucked out. I just happened to be at the right place at the right time when I became a trial consultant, because I was called in to do witness prep with a witness who was having anxiety attacks over testifying in court. And a lot was hinging on this witness's testimony. And with my background in clinical psychology and family therapy, I was brought in to work with this witness and help deal with the anxiety aspect of it. And then I was there in trial and asked, what did I think about this, that, and the other thing, and what were my observations? And the trial consulting firm, it was in Atlanta, and happened to need more assistance with other things. And so I just kind of grew into filling that spot, which has been a perfect fit. And I've been doing this for over 20 years. It's hard to imagine.
Well, and I think, so if somebody's their family's been in a catastrophic event, and they have a lawsuit or a claim, and their lawyer recommends that they hire a trial consultant. And I always talk to my clients about it because it is an investment. I look at it as not a cost, but more of an investment in their case. And they ask me questions about it, and they don't know sometimes even what to ask. But how would you? I mean, how is one to determine whether they have a good trial consultant? I mean, because there are people out there right now, quite frankly, that are hanging their shingle out and holding themselves out as trial consultants who don't have the experience that you have, or that's any of the great trial consultants have. And I'm just curious, and I've seen them. I've seen something that sometimes I'm excited when I Google the defense trial consultant. Because like, oh my goodness, we've got a really good chance now because that person really is not qualified. But so how do you know a good trial consultant versus a bad trial consultant?
So I would interview them like you do anybody else who you're wanting to work with and hiring to do a job, and ask about references, their track record, publications, how long they've been doing this, and common sense questions. What can you do for me? And see how they respond to it. And I think that there's a personal aspect to it too. It has to be a good fit. There are a lot of cases where we'll work pretty intensely with the attorneys and with the witnesses, the attorneys' clients and their witnesses. And so the personalities have to mesh. And if there's not a good feeling around that, then it's probably not going to work out as well as it could.
And I think having someone with your level of experience certainly helps. I mean, I would assume over the years, you've been doing it for 20 years or over.
Yeah.
You've gained a lot of insight by doing that. Isn't that true?
Oh, absolutely. I'm definitely, I also grow with each case and each trial team that I work with, and learn more from my other trial consultant colleagues who I work with. And I think it was really important when I started out that I started out as an intern and then as an associate. And I had really the best mentors in the world. I mentored with Andy Sheldon and Deanne Sinrich in Atlanta, and then with Eric Oliver up in Ann Arbor, Michigan. And, I've had the wonderful opportunity to work with Catherine James and David Ball and Artemis, and those mentorships. I think we all get better when we work together and can learn from each other.
I know I'm a better trial lawyer today than I was when I started. And I had to start on little trials and had to get in a courtroom and try cases. And sometimes I learned the hard way. But you're always learning. I hope to be a better trial lawyer 10 years from today than I am now. And so it is one of those things that the more experience you have, the more things you've seen, the more you realize, I think, that maybe you don't know everything, that there's a lot to learn.
Well, that is, one of the biggest teachers for me, David, is working with lawyers like you. I learned so much from you and your experience. And when you identify areas where I can be of assistance, and I'm not a lawyer, nor do I pretend to be a lawyer. And so you kind of fill in that background for me. But the better the lawyers are who I work with, the better it makes me. And so it is a privilege to work with lawyers with your experience. And one of the best teachers for me was my dad, actually, starting at, I think, the first trial I observed of his. I was 10 years old, sitting in the back of the courtroom, and I had a Nancy Drew book sitting next to me, and I was told to read. It was called The Secret Locket, and I was told to read my book and not make a peep. And I think I just happened to be able to go there because there was a snow day. And so I wasn't able to go to school. And so I was sent to the back of the courtroom in Jackson County, Indiana. But I didn't read a page of that book. Even at the age of 10, I was just so fascinated. And it was such a learning experience. And I have vivid memories of that still influence how I work with lawyers today. And one of them is my dad was the same person in the courtroom as he was and still is, sitting at the dinner table eating ice cream after dinner. His voice sounded the same, his demeanor sounded the same, and the jurors could feel that and see that, that he was the real thing. And so that's one of the lessons I carry with me is, I think that's important for the jurors to experience. And you're the same. I experience you the same way, David. You're the same person in the courtroom as you are when we run into each other on the sidewalk and we're just, catching up for a few minutes. And I think that's what makes some of the great lawyers really, really great. It's one of the qualities.
Well, for those who don't know, her dad is Roger Pardick, one of the best trial lawyers I've ever seen. And we all learned a lot from him over the years. And he was one of those that's kind enough to share, whether it's on a listserv or whether it's a seminar or whatever. I always loved working with and listening to Roger. So you had a great mentor and a great teacher.
I did. Absolutely. Absolutely. And the same was with my mom. She had a family law practice. It was kind of a different perspective. But, in her day, being a female lawyer had its challenges in a small town. And so I got to learn a lot from her as well, which is also very beneficial, when we're working at cases.
Yeah. Well, and I do think it's important for people, their lawyers to be who they are. I sat through a trial once where one of my associates or one of my attorneys was trying the case, and this is years and years ago, but I was hearing my stuff. I was like, they were using my stuff that I used in trial. And I'm like, no, don't use it because it's not you. It's not you. And jurors are really good at detecting when you're being fake. You have to be, whoever you are, be who you are.
Yeah.
And I think that's, but sometimes, again, we're not trained necessarily that way. And some people are not comfortable kind of opening up as to who they are. And they feel a little bit more vulnerable. But I find that jurors like that in people. They like humans.
For sure. Yeah. When you can laugh at something funny, or you're serious when it's something serious, when you dare to be expressive in the courtroom, I think that's important. And it's a little bit of a balancing act, right? Because our job is also still to provide the jurors the information they need in a way they need it so that they can make the right decision about the case. And so we can't let who we are, if somebody happens to be a clown, that probably needs to be dialed back a little bit in the courtroom, right? Or if somebody is, has a huge, big personality and tends to be kind of a bulldozer or something, that needs to be dialed back in the courtroom. So, it's a balancing act, but, that's part of our job, is to identify those things that the jurors need so that they can do their job. Same with the witnesses.
Well, let's talk a little bit about when someone uses a trial consultant. I know, from my own experience, there's different times and different ways, but when is somebody brought in, and when should somebody be brought in?
Well, I get brought in ideally early in a case, and we will, possibly do a focus group that can be used as a guide for discovery. Sometimes we even do focus groups before a case is filed so that attorneys can decide, do we want to file this case, or do we want to maybe use the feedback from the focus group to handle it differently. So, the earlier the better from my perspective, but the reality is I don't always get brought in early, and it can be further along when people might be preparing for depositions or settlement, mediation, or trial preparation. Clearly, I mean, that's probably when I'm brought in the most, is when the attorneys and their clients, when the heat gets turned up. And I think sometimes the thought is to save the expense until we really need it, when in fact, my experience is more often than not that the earlier I'm brought in, that can actually save expenses, because we can identify sometimes what experts are really needed, and sometimes we identify experts or witnesses that aren't needed. So you don't have to spend money chasing down some rabbit trails that may not be necessary. So it kind of runs the full gamut. Actually, sometimes I brought in after a case is already over. and I'll do post-verdict interviews, or I've even done focus groups on cases that are already over, because the attorneys want to learn a little bit more insight into what happened in the courtroom, and make decisions about, do we want to take more of these cases? Do we not want to take more of these cases? So there are sometimes decisions made after trial's over that can influence bringing me in.
I know I've had opportunity to work with you at different stages. And I think probably the most helpful is, we brought you in to do focus groups before we even decided before we even file a lawsuit. And I think it's real important for the folks that are listening, the clients, is that, again, we know the law, but we don't know how people are going to perceive this case. And I think the most dangerous thing that any of us can do is to assume that we know. And sometimes the more we do things, the more we start to think that we know how people are going to react. And that really is dangerous. And so it's always eye-opening to me. I've never sat through a focus group where I didn't learn something. And the earlier I learn that, the more helpful I can be. So let's talk a little bit about, getting involved early and why that is so important.
I do focus groups almost every week, or actually right now I am doing them every week. And I do so many, I kind of start out with the expectation, I've heard it all. I can't be surprised by anything somebody says. But I am constantly learning new things every single time. And, there are comments from the focus jurors that if you and I had worked on this case for the next 5 years, we wouldn't have come up with. And actually, that's the whole point of doing them, right? It's that they come up with things that we don't. But I think, not all focus groups are created equal either. So maybe we talk about that a minute, because there are all kinds of focus groups, and it's not one size fits all. They have different purposes, they have different benefits. They can have some disadvantages if they're not done properly. And I think it's really important when working with a trial consultant that you identify what we want to accomplish with this focus group, and then choose the right format to accomplish your goals. And there are some trial consultants who do only one standard format, and that's it for all purposes, no matter what. And that I would be a little bit concerned about, because, like I said, doing a focus group to decide whether to file a case or as a guide for discovery is a completely different animal than doing a focus group for trial preparation and honing your presentation that, when the facts have already been developed.
Well, and I think that's a good point. I mean, I think some folks may not even know what a focus group is. So why don't you just kind of explain to us what a focus group is, and not, I mean, I know there's different types, maybe just touch briefly on those.
Right. So the two big sort of different types are, one, they're called either concept or narrative focus groups, where small amounts of information are given to people who look and sound like jurors, typically from the trial venue. And then we get feedback from them, usually verbally, but the feedback can also be in writing when they fill out written questionnaires, and ask, we'll give them a little information about the case and ask them what's their impression, what are their experiences with the information that's being presented to them, because the research says, so it's got to be true, right? Right. At least the research says that jurors spend 80% of their time in the deliberation room discussing their own personal experiences. So to do our jobs, we need to find out what people's personal experiences are with the different aspects of the case, whether it's a trucking case, people's experiences with semi trucks driving on ice, or people's personal experiences, driving west into the sun at sunset, or, there's a whole myriad of different things that people have personal experiences with that apply to these cases, from the liability standpoint of it. And then also in terms of damages, what are people's personal experiences with chiropractors, if the injured person treated with a chiropractor, or with brain injuries, if the plaintiff has a brain injury, and different sort of constellations of facts trigger different experiences that jurors might have, and what those mean to this case. So that's what we aim to find out with the focus groups. And I started out saying there's a narrative concept kind, where we give the jurors just a little bit of information, or focus jurors, give them a little bit of information at a time and get feedback from them on that. And then there's an adversarial focus group, where each party is represented by an attorney, and they present adversarial presentations. And the presentations could be just the opening statements, or we could spend a whole day and there could be adversarial presentations of the openings, of the evidence, of the closings, and then the people will be divided up into deliberation groups and actually go deliberate the case to a verdict at the end of the day. And when we do that, we like to have at least 3 different deliberation groups, so that we can, oftentimes those deliberation groups will come back with different verdicts, which can be very informative to us. And what are the common denominators, and between those verdicts, and then what are the differences? How did they each arrive at their different verdicts, can be really informative.
And I can imagine that, I mean, you get to do these all over the country. And so I would imagine that you could have the exact same fact pattern in one state, in one county, and you could probably go to a different county in the same state and have a different result, and certainly a different state in the union, you would have a different. So you could have the same thing, but people perception of those same facts are different depending on where they live.
That's why we really aim to do the focus groups and mock trials in the trial venue, if we can. And the only reason we wouldn't do it in the trial venue is if the trial venue is too small and we don't want to risk confidentiality issues with, people finding out that this is taking place, and we don't want to risk contaminating the jury pool or something like that. So then we'll go to a different county and match the demographics of the trial venue with the focus jurors who we recruit from a different county.
I know you and I worked together on a case in a union city. It was a heavily predominantly union county, and we had a case where a semi driver was driving on ice, and he was clearly violating the Federal Motor Carrier Safety Regulations. He was clearly violating the Indiana CDL manual. He was clearly violating the state law. He was talking on his cell phone from the point he picked up his load until this wreck happened, which was, and like over an hour. He was talking to his girlfriend, and he was just distracted. He had slid through one intersection, and then he slides through another one and hits my client, and then he cusses on the phone while he's talking to his girlfriend. He calls my client a derogatory name, and I thought, my gosh, everybody's going to hate this truck driver, and I thought, and I know from trying cases that, I would like to have some responsibility shifted to the company, because the company hires this person and they train this person. They're responsible for this person. But I thought, boy, if there's ever a time when they're not going to blame the company, they're going to blame this guy as this particular case. And I was wrong. Your focus group showed me that. My wife will tell you I'm wrong a lot, but that I was actually, I just couldn't believe it. How they stuck up for this person.
Well, they were worried about him, right? They were worried about if there would be a verdict against him, that it could have an effect on his future employment opportunities, and that the company might have been putting pressure under him, that there could have been consequences if he hadn't met the deadline or the time when he was supposed to deliver the load. They were kind of the focusers were putting themselves in his shoes, and they were worried about him and sticking up for him. And so we shifted our focus to the company. But I remember people saying, well, my husband works over here at the factory, and if he doesn't show up, no matter what the weather is, they'll fire him and replace him with someone else. And then how's he going to provide for our family? Right.
And so it was very enlightening to me to hear that. And then so people who are listening, it gives the lawyers some guidance then. Okay, so if I go try that case without knowing that fact, and I go try to make this guy look bad, because I believed that he was bad, he was dangerous driving, I could have really hurt my client's case unintentionally, by not knowing how people in that county would perceive these facts. And that's a perfect example, I think, of why lawyers should and clients should allow their lawyers to do these type of studies, focus groups.
Yeah, we really didn't see that coming, did we? Because there were so many violations, so many driving violations that he had, that it seemed just like a slam dunk, and one of those things that you just take for granted, that this is an open and shut case. And it was eye-opening. And fortunately, you were able to, we did the focus group early enough that you were able to shift the focus in discovery and not be blindsided by it.
And we've done that now, where we've got cases that are, they're the huge cases, the multi-million-dollar cases. Those are going to take a long time to process, for the most part. I mean, it's going to take a while for us to get from the beginning to the trial or a settlement. And so what we've done is we start off in the very beginning, because I want to know right in the very beginning, okay, how do people just perceive these facts? And then that guides us into our discovery, like you had mentioned, drafting discovery, drafting the kind of the focus of the case. And then, our intent is, once we gather some information, I assume then that's a good time to go back and try another focus group to see if, now we have some new stuff. What does this do to it? So do you do multiple ones?
We have done that. We have done multiple ones. I think the most focus groups I did on one case was 6 focus groups, but that's unusual. And it was a really, really difficult case. And fortunately, it paid off in that case. But, part of it too is, David, first of all, you're so smart to be asking the questions. I think that speaks so highly of you, that you're interested in the different perspectives. But the other thing is, it gives us an opportunity for the attorneys who don't have much experience in the courtroom to develop presentation skills, basically to practice. And especially after COVID, I know, most attorneys have been out of the courtroom for quite some time. And it's like with anything that you want to do well, you can hone those skills and practice. Even, it's interesting, because sometimes I experience that the most experienced attorneys like you are the ones who want to practice the most. and get better and maximize, your skill level and your potential. And you seem to benefit the most from it.
I think that, I mean, I send all of our associate attorneys out to the best trial lawyers in the country, whether it's Lanier or whether it's Mitnick or whoever. Whenever they're running seminars, I send them out there, and I go because we want to be better. I think when you don't want to get better, then you maybe want to hang it up, because I think that we have so much to learn, and that's what I love about working with trial consultants, is because they focus on what we should focus on, which is ultimately my job is to get the best result for my client, to make the most positive difference in my client's life. And for me to do that, I have to know. And jurors change, times change. And so what worked 5 years ago may not work today. And so you can be an extraordinarily successful trial lawyer and have been very fortunate and walking in and out of courtrooms. And then all of a sudden it changes and you're not successful. If you're not keeping up and you're not using trial consultants, how in the world would you know that?
One of the things that worries me most is when attorneys say, I want to do it this way because that's the way I did it in my last case. Mm-hmm. Well, maybe that applies to this one and can work just as well. But maybe not. We need to figure out, because different strategies apply different times. And it is so true that juror attitudes are evolving, and it is important to kind of have a read on where they are, and particularly how they apply to your case. Juror attitudes have been affected enormously by COVID. Some people are just so over it that they don't want to hear another sob story about somebody being injured or laid up. They can't handle it. And other people, because of their COVID experience, have become more sensitized to somebody who is injured and laid up and has mobility issues or limitations that they didn't have before. And then there's everything in between. It's not an either or. And it's, I think, we're all enormously influenced by social media and by politics and our work situations, the economy, and so forth. And all of those things play a role in how jurors make decisions. They can't help it. We can't leave our attitudes and our opinions and our experiences in the car like a cell phone. They come into the courtroom with the jurors, or into the focus groups with the focus jurors, and they go into the deliberation room with the jurors. We can't siphon those out. So having a feeling of what those are and how they are influencing jurors' decisions about your case, it makes a difference. It makes a difference, I think, in terms of how we present the case, so it's meaningful to the jurors, how the lawyers work it up, and even maybe how confident sometimes lawyers feel in the courtroom. When we've done our homework, when we have done the jury research and have a feeling for what attitudes we can anticipate and what role they're going to play, then the lawyers kind of know how to adapt to that and adjust to it, rather than, kind of just be guessing out of nowhere.
From my perspective, I don't know how you try cases without it. It's certainly significant cases. I mean, I spent over 35 years learning to be a trial lawyer and studying and reading, and I only know how to really try one area, which is personal injury. Mm-hmm. I would not be as effective in a criminal case. I would not be as effective in a divorce case or any other type of case. Because all my resources, all my ability, all my reading, all my studying, everything is done in this area. Now, there's these folks out there called trial consultants, and all their focus and energy is spent on how to be how lawyers can put on a better trial, and how can they be a better communicator. And so why wouldn't you go use these folks? So if you're a client, you're out there and you're wondering, it's silly not to, because there's a difference between the lawyers. If you hire a divorce lawyer to handle your truck wreck case, I would be of the opinion that that's a tough challenge for that lawyer. If you hire a truck lawyer to handle a truck case, that's a step in the right direction if they really have tried these cases and they know how to do them. But they can only do so much. I mean, whether I've tried cases in Missouri. It's been different than trying a case in Indianapolis. I've tried cases. I had the most recent one we were going to bring you in was Bowling Green, Kentucky, where only 25% of the people have been vaccinated. I was worried. What is that? What does that mean? In the court, we didn't have to wear masks. We weren't going to, and I was worried because I have no idea what it feels like to live in Bowling Green, Kentucky. And so whether you're in St. Louis, wherever you're at, people are different. And that's where you help us realize what is the difference and how do we effectively communicate with these folks.
Mm-hmm. Yeah. So I think, we talked about that applying to focus groups and trial presentation. I think it applies just as much to preparing your witnesses to testify in court as well. So like you talked about us learning about the focus jurors' attitudes about the defendant truck driver, and they were way different than we anticipated. And that happens too with your witnesses, that sometimes the lawyers will really like their client and just be convinced everybody's going to like this client because this person is so lovable. And then it happened recently. I was working with someone, and part of the reason people liked her so much is that she smiled all the time. And that's the first impression, when somebody smiles all the time, people seem to like that person. But the smile was a cover-up for pain and insecurity and nervousness and dealing with the injuries that she had dealt with. And so she wasn't all smiles, but that was just, the first impression. And so when we were working together and able to identify, what's going on with this smile, what else is there, what's behind that, that was the real stuff. And it was important for the plaintiff lawyer to bring that out when that plaintiff was on the stand, so that the jurors knew what the smile meant and they knew what was behind it and what else was going on with that person. So if at the focus group, we showed just a short video clip of this plaintiff, and it was the smiley version, and it made the injuries seem kind of superficial and minimize them, but it wasn't the real story. And the jurors need to know the real deal. And we all have coping mechanisms. I give this woman credit for smiling her way through her pain in some way. That was a coping mechanism that worked for her in her real life and got her through. It was important that it wasn't misinterpreted or misunderstood, and for people to know what it really meant.
I think that's and for folks that are listening that aren't familiar with what we do, witness preparation is something that is what we, a lawyer that doesn't prepare their witnesses is not doing their job. And so, but that doesn't mean, and I get this, people say this all the time, but that doesn't mean you prepare somebody to be fake. It doesn't mean you prepare people to lie. It doesn't mean you prepare. It's just like what Amy just talked about, is that you need to know more and how this person thinks and what is the story behind the witness. But I want to make sure that, because again, people don't know, and we see so much stuff on television that is just, sometimes it's really unethical what I see in movies or in TV. Right. And so that's not what we're talking about. We're talk a little bit more how you work with and prepare witnesses.
So you do a great job at this, David, and that is, you do not, and really the great trial lawyers and trial consultants don't tell the witnesses what to say. You don't put words in their mouths. Actually, what you do is ask questions to get to the core of what's really going on with them, or what information the jurors need. And sometimes the plaintiffs don't know themselves, if they're depressed, for example, if they've been depressed after the wreck and they weren't before the wreck, sometimes they haven't been put in a position to put words to that, and identify what is really triggering it. And we have to put words to it so the jurors and the judge can understand what's going on. And really that process is just spending time and asking the hard questions and listening, really listening to what they're saying and working to understand it. And I think lawyers are brilliant wordsmiths, and that words are your tools. And so dialing that back and really being in listening mode when you're working with the witnesses is one of the things that that many of us can learn from you, David, because that's one of the things that you're exceptional at.
I love the time that I get to spend with witnesses. I love going to my clients' houses and meeting people, going to the witnesses' houses and meeting people. I learn so much more about people when I get to see them in their environment rather than my environment. And because sometimes it doesn't match up. You're like, oh my gosh, this is not what I thought.
Yeah.
And so I do think that listening and asking. My dad was a psychologist. Your dad was a lawyer.
Yeah.
My dad was a psychologist, and so I have a appreciation and respect. I used to just love the fact that my dad would listen.
Mm-hmm.
He would just listen, and he saw the good in people. And I think so that helped drive me to what I do. I wasn't smart enough to be a psychologist, so I decided I would be a lawyer instead. But I don't have that fancy vocabulary that you talked about. But I do like people. I love people, and I think that it helps. And some lawyers maybe don't love people as much. They don't really, that's not their thing. They want to, they like to hang out. I hang out with anybody and everybody. I don't hang out at the fancy golf clubs or whatever. Nothing wrong with that, but that's not me. But I think the less contact you have with everyday ordinary people, the worse trial lawyer you're going to be. And the more important it is to have people who can relate to people and who can help you bridge that gap.
Well, it's more than that with you, though. I agree with everything you're saying. Absolutely. I feel like with you really care about the person. It's more than doing a job. Your interactions with your clients and with the witnesses, I feel like it's way more than just doing a job. It is caring about them and wanting to do what is absolutely the best for them, and then ultimately for their case as well. And I think that that's coming from a different place, than just having a checklist and checking the boxes. We have to talk about these topics. You're going at this about what is important to this person and what are their needs. And then not only that, but what are the judges and the jurors' needs from you and from your witnesses. I think you care about them just as much because you're coming at this from a people perspective, which is, yeah, I love that.
Thank you. Well, let's talk about mock trials.
Yeah.
So one of the other things trial consultants do is a mock trial. So tell us a little bit about what a mock trial is and how does that work?
So mock trials are usually bigger, longer, fuller focus groups. So we'll have more deliberation groups, show video of the witnesses, have people fill out questionnaires as the day progresses, and sort of get temperature readings from the mock jurors about different stages of the trial, different witnesses. But you go through basically a mock trial is a Reader's Digest version, if you will, of the trial, just kind of a truncated version of the trial. And those can last all day. They can last 3 days. And the other thing sometimes that you'll see trial consultants work with are shadow juries, where they'll have jurors who in the courtroom who are observing or shadow jurors. So there's the jury in the jury box, but sometimes some trials have shadow juries where people will be brought in to observe the trial, and then the trial consultant will debrief the shadow jurors in the evenings to get their feedback on what they understood, what their impressions were. And those usually happen in cases that are pretty technical and complicated. Some patent cases or accounting cases that, where we're really concerned about is is this meaningful to those of us without that background?
Have you ever been in a trial where both sides had shadow jurors?
I have not. I have not.
That would be fascinating to me.
Yeah, I am involved in more and more trials where both sides have trial consultants.
Yeah.
That's becoming almost standard, especially in the larger trials.
Yeah.
So that's becoming more common. And I tend to see some of the same trial consultants in trials repeatedly. We wave at each other.
Well, I know one of the other things that trial consultants that help us with is our exhibits and what evidence do we want to present, not only in document form, but in testimony form. And I think that's helpful. Clients tell me all the time when they hire me is that, well, this is a simple case, and so, why don't, here's all the facts. And young attorneys, or not necessarily young in age, but young in experience, they have a tendency to want to put in all the evidence. If it's relevant, boy, gosh, I'm going to put it all in. And the worst thing is I'm always working with my other attorneys. It's like, no, do you really need this fact? Do you need that fact? I just actually yesterday is telling my partner, I'm like, no, that fact, I know it's relevant, but it's not helpful. And so tell us a little bit about your role in doing that.
Well, sometimes what's relevant to the attorneys and from the legal perspective is not relevant at all to the jurors. And so we have to sort that out, because I have that experience too, that a lot of attorneys think the more facts, the better. Yeah. However, the jurors often, if you look at it just from a factual perspective, all of the facts, can drown the jurors. The jurors get lost in all of the details and can't see the forest for the trees. And that's definitely, a sorting process of what do we need. And it's not just it's actually, what do the jurors need? That's the question. What do the jurors need to do their job in this case? And I can guarantee you there's a huge difference between what the jurors need and what many attorneys think they need. And definitely focus groups and mock trials can help us sort that out. But also just asking the question, what do the jurors need? What of all of this information furthers the ball, and without us getting lost in the weeds? Because all of our attention spans are shrinking. That's part of this age of technology and sort of instant gratification. We can go on Google and have an answer in a second, and we're inundated with all of this input. And so we have to be cognizant of how much attention and bandwidth, so to speak, the jurors are going to give us, and cater to that so that we don't lose them in the process, because we need jurors who are going to be engaged with us throughout the trial, and not, they get really impatient when they're hearing the same thing over and over again. They get really impatient with redundancy, and the risk is they're just going to tune out, and then we haven't done our jobs. So, we don't want to put on a dog and pony show for entertainment purposes. That doesn't serve anybody either. But we definitely need to be cognizant of attention spans and being direct and concise. It's a balancing act, right? Because they also need enough facts to be able to, the jurors need enough facts to be able to do their job. So I think that's a process. And a lot of times, so I was editing an opening statement just a few days ago, and the first draft I got was 61 pages long. And I couldn't get through it. It just wore me out. Yeah. And I was like, oh my God, I had to back away from it. And then I actually couldn't edit it because it was just too overwhelming. And so what I ended up doing was making an outline and outlining the big topics, and then going back through the opening and identifying what in here fits into these topics and what can we dispense with.
Well, I think that, and even with lawyers, I know my partner is extraordinarily smart and knowledgeable of the law. And so when we try cases together, I'm not, and I don't need to be, because I have him. I know what I need to know.
So it makes you a perfect team, though.
Yeah, and it does. And I think that, I mean, he tells me, here's what you need to keep your verdict.
Yes.
And so that's important. And
yes.
You can't lose sight of, okay, I just want to put on this presentation that's persuasive and informative, but I also have to maintain, and I've always been able to keep my verdicts, because he'll say, Dave, you need this one question and you didn't ask it, go back and ask it. And so I think, again, there's a fine line. We have to present a case that a juror finds persuasive and doesn't bore them, or they get bothered because it takes it. But at the same time, we do have to hit that legal criteria.
Absolutely. Yes, absolutely. Yeah.
Well, I think I can't talk about jury or focus or jury consultants unless I talk about the TV show Bull.
Oh yes, good. I'm glad you're.
I watched it when it first came out because I wanted to know. I didn't want to watch it to be entertained. I wanted to watch it because I was afraid. Okay, here's what jurors are going to think, and I wanted to see what in the world was that. And I swear I don't know. I quit counting how many unethical violations I saw in the first episode that I watched.
Right.
But talk about how that's not real, or is it real? Tell me a little bit about the Bull TV show for those folks who've seen it.
Well, I think it's wonderful entertainment, but that's kind of the extent of it. So in the world of trial consulting, none of us have red and green flashing screens, on our walls with the jurors' faces on them, bigger than life. Or, it would be unethical to go out and, chase down the jurors and follow them around and videotape them and things like that. That doesn't happen, or if it does, it should not. My main tool that I work with as a trial consultant is a notepad and a pen, and unlike on Bull. So I do get that question a lot. When people find out I'm a trial consultant, they'll say, "Oh, that means you're like Bull." And I'm like, I don't even know what I can relate to from that show in real life. There isn't much, to be honest, other than that it's entertaining. And I don't even know what to say about it.
Well, what other types of things do you think folks should know about trial consultants or using trial consultants that maybe we haven't chatted about or talked about?
I think one of the concerns people have is cost. And, obviously we have to charge for our fees, but I think that there's the whole array of services from trial consultants. Our services can range from an hourly rate that is budget friendly, to, tens of thousands of dollars and everything in between. And so when I work with clients, the question is, what does the attorney in the case and the plaintiff, what do they need? And how can we best go about what service serves you the best and is budget friendly, or can the budget tolerate? And then I tailor my services to that. So, and every trial consultant works differently. Some people don't work that way, and some do. So I think that the cost doesn't need to automatically eliminate people from engaging a trial consultant when we can tailor our services to the needs of the budget and the case and the clients and so forth. So that's an important part of it. There's no standard this fees also from trial consultant to trial consultant range enormously. So they're not standardized. So you just have to, call the trial consultants and find out how they charge.
Well, and I think it's an investment. I mean, so if with the right use of a trial consultant, is certainly an investment in someone's case. And the question is like any type of investment, what is the best use yourself? Somebody who I trust is say, okay, what do you think we should do?
Yeah.
What's your recommendations and how do we go about it? And
well, that's something that we've decided together, right? We'll decide, what do we want to accomplish? What does the case need? What do you need? And then what best will serve you? And that's a joint decision. I often will make recommendations, but don't dictate it needs to be X, Y, and Z. I think that it's a collaboration.
I think folks that hire, that have a significant case, we invest money in a lot of different things, and meta visuals. I mean, I remember when I first started, I had terrible exhibits, and today I have really good exhibits, and then I have animations and I have things, but sometimes I will invest thousands of dollars in something only to find out that I can't use it because it's not effective.
Mm-hmm.
You have to be you have to be willing to say, okay, it doesn't really matter. I'm going to invest money in something. I'm going to try to do the best that I can. And then I'm going to be willing to walk away from something if my trial consultant tells me after focus grouping it that it's more damaging than it is helpful. Well, and we learn that.
Yeah, I mean, we've done that with your exhibits, right? We've tested those at focus groups and found out how they need to be revised, or what the focusers need to see in order to understand the injury or to understand the liability or how the wreck occurred. All of those things, a picture is worth 1,000 words. And oftentimes the focusers can tell us better than anybody what it is that they need to see and how they need to see it in order to make sense of things. And that's also often a sorting process also, right? Because the inclination sometimes is to put together, for example, a treatment timeline and to put all of the information in there, and then people can't sort out what the heck it says. And so we go through this distillation process with the demonstratives as well and identify what's the message and how do we really convey that visually.
And I think that trial consultant can save you money. I mean, so you invest money on the trial consultant, but at the same time, if they tell you, because clients have no problem if I spend $10,000 or $20,000 on an animation. But if the idea that, we talk to the focus group and animation is not necessary, mm-hmm. Why invest the money in it? Just because, I mean, the animation companies, they'll tell you every time, right, you need an animation and you've got to have this animation. And I remember I tried a case where I had an animation and I regretted having the animation, because I didn't focus group it. But there's a tendency when you're a young attorney, if you invest the money in it, you feel like you got to use it. Mm-hmm. And the great thing about having a trial consultant in the earlier stages is they can tell you don't even need it. Sometimes a simple chart or a simple diagram or some may just be as effective as something that you would spend thousands of dollars on.
Right. The flip chart and a marker.
Yeah. So I think that's, again, on the cost side of it, I look at it as to say, if you invest in a trial consultant early, then it can save you money down the road.
Mm-hmm. Yeah. Yeah. I mean, I definitely consider myself a member of the trial team. And so it's not me telling you what to do or you telling me what you need or what has to happen. It's a collaboration, us working together to maximize the value of your case or put it on at trial in the way that can be most useful for the jurors.
I mean, I tell people, there's times when I'll spend $10,000, $15,000 on the front end of a case to find out that I have no case. And my clients don't have to pay me back that money. I just lose that money. Mm-hmm. And where I see other lawyers, they don't put the money in the front end to find out that they don't have a case. Mm-hmm. And then it's years later when they find out they don't have a case. I would rather find out the strengths and weaknesses of my case, whether I have a case or I don't have a case, on the front end. Mm-hmm. And I think that's true with the jury consultants.
Well, if you carry a case for years and years, only to, keep investing in it and find out down the road that it wasn't worthwhile. Then you're not only investing the money up front, but you're doing it over time, and it doesn't really get you anywhere.
Well, I know that that the thing I love about working with you is how passionate you are, how you really believe in what you do, and that's one of the things that I relate well to. I think that's important when you're working for someone. But from doing this now for over 20 years, what do you love about what keeps that passion?
So I think one case at a time, we're making the world a better place. That's a big part of it. When we're holding trucking companies and truck drivers accountable for violations that hurt somebody, or a manufacturer accountable for a product defect, or a doctor accountable for medical negligence. An attorney recently said in jury selection that she was taught as a girl growing up, if you make a mistake, you apologize for it, you own it, and you fix it. And doing those things makes the world a better place. And unfortunately, we have these cases because the defendants aren't doing that. They're not apologizing for it. They're not owning it. They're not fixing it. And so we have to hold them to the grindstone. So that happens, because if there's not accountability, they can keep hurting people without any consequences. And so I think that, the system that we have works for the most part, not always ideally, but our job is to make it work as best it can. And I think that most of the time we do that, hopefully, and that's the goal. So it's to make the world a better place on a larger scale, but then, for each plaintiff and for each case, when they've been injured, and the only way that they can be helped is with money. That's the only fix or the only remedy available to them. And so I see it working more often than not. And sometimes with these cases, it's not only helping the plaintiff when they receive a recovery, but I think it helps the defendants too, to be held accountable and to have closure, and to acknowledge. Then they're kind of forced to acknowledge the wrongdoing, and they can hopefully make better choices going forward. So I think it's not just for the plaintiff that we're doing this. I think that there's a lot of benefits for the defendants as well, even though those might be a little bit harder to swallow.
Well, I think that I appreciate everything you do for my clients and for the folks out there throughout the country that you have an opportunity to work for. I think there's nothing like, my clients hugging me before the verdict even comes back, before they even know what the number is. They hug me and thank me with tears in their eyes, saying, thanks for helping me tell my story.
Right.
There's nothing like that. I can't imagine what other profession I could be in where you have that opportunity to touch people's lives. And I'm honored every day that I get to do that. I had a client here just recently who agreed to take $500,000 less if the company would just change the policy and make it safer for everybody else that's on the roadways on a big trucking company. And I was so proud of, I suggested it, but I said, it's up to you, we can either get this number X or we can get Y, which is $500,000 less than X, but they have to change policies. They have to do things to make it safer for their trucks. And my client said, I'm okay with that. And unfortunately, the company picked Y, and we got $500,000 less, but they're now going to be safer. The roads are going to be safer because of my client. And I would have loved to try that case. From a personal standpoint,
yeah,
it's not about me. It's about my client. And what a great opportunity, and how good a feeling it is when you make the world safer.
Mm-hmm.
And that's what you do by helping plaintiffs win these cases. Or even what I find is if you prepare well and you've done your homework, a lot of times you don't get to try the case. You know? Yeah, so, but thank you for everything you do. I really appreciate it. I love working with you. I know we'll get to work a lot together in the future, and thank you for taking the time to be a guest on our podcast.
Well, likewise, David, it's an honor to work with you and to have been able to talk with you about this today. And I think that the podcast is really important to get the information out there. And so I appreciate that you're doing that.
All right. Well, thank you very much. This is David Craig, and you've been listening to After the Crash. If you'd like more information about me or my law firm, please go to our website, ckflaw.com. Or if you'd like to talk to me, you can call 1-800-ASK-DAVID. If you would like a guide on what to do after a truck wreck, then pick up my book, Semi-Truck Wreck, a guide for victims and their families. This is available on Amazon, or you can download it for free on our website, ckflaw.com.